So, those of you who have been here for the last half hour, welcome. Thank you for hanging out with me. Thank you for the chat. It's been amazing. Now, here's this. Hey, Terry. Hey, Jerlay, Zach. Hey, Barry. Tev. What is going on, ladies and gentlemen? Welcome to Lone Wolf Ouza's Week in Review. We have court cases for you, and they're coming up soon. Good morning, Melinda. Not far now. Not far at all. Ladies and gentlemen, I do want to let you know we have 3 hours, well, almost 3 hours, not quite. Just shy of 3 hours. Full of crazy content. We're going to start off with Judge Chisholm today. We're going to move very quickly to Judge Simpson, where we're going to sit for quite a while. Judge Chisholm begins the week on Monday. Judge Simpson takes us into Tuesday. Then, with Judge Perkins, we're going to see a little bit of Wednesday and a little bit of Thursday. And we're going to finish off the week with Judge Webster, who had a Friday fabulous case. One that everybody should see. It's interesting as heck. I can't even talk it up enough, but we're not quite there yet. Ladies and gentlemen, welcome to Lone Wolf's Weekend Review. We're going to get things started just in a couple of minutes. Thank you, everybody, for coming to hang out. I don't know what else to say. That's it. We're starting the show. How you doing? Let's get ready. Get some coffee. Get some refreshments. About that time. Dev, there's going to be more than one, but I think you can probably guess. Yes, you can definitely guess which ones they will be. Ladies and gentlemen, welcome. You know what that little sound means? We're getting things spun up here. The show is getting on the road. Buckle in, ladies and gentlemen. We want your hands and feet inside the ride at all times. It could get turbulent. It could get dangerous. We're starting things off with Judge Chisholm this morning, and he's got a sovereign citizen who is not happy about their traffic infraction. You know how those things go. We're moving very quickly, as I said, to Judge Simpson, and he had a whole day full of craziness. But before we get there, we're going to check in with the sovereign citizen in Judge Chisholm's room for Monday. It all starts right now.
I already did. It's up. They're muted.
Thank you very much to Sovereign Citizens Encounters.
Your screen name is Alendra Johnson. Is that your name?
No, I am Alina Waters, representative, authorized representative for the trust.
Sovereign Citizens Encounters sourced this for.
We're going to rename you so we don't lose you. And we'll change it to WA.
Thank you, Hutch. You're a good
And
fellow.
we're going to need to put you back in the waiting room, but you'll be back under a name that we recognize. So we know you're here, and you're about 15 minutes early, which is wonderful. If the officer comes in early, then we could start early if you're both here. We can't start early without both of you here.
Thank you, Your Honor.
Here we have Ms. Waters and we have Ms. Spangler, and this is 25P 139786. People of the City of Royal Oak versus Alina Lee Waters. Ms. Waters, you've been cited for a parking violation of parking head in on Washington with a parking where that is prohibited. All the parking has to be backing into those spaces. Are you here to admit or to deny responsibility, or to admit with an explanation?
Deny.
Okay, raise your right hand.
For the record, I'm
For the
not.
record, please raise your right hand.
Mm-hmm.
You swear or affirm that the testimony you're about to give in this matter will be the truth?
I affirm.
Yes.
Okay. And the officer will testify first, please.
This violation occurred on May the 23rd at about 11 minutes after noon. It was at 608 South Washington. That is an area that is heavily marked as being back in only, and the vehicle was parked facing forward in. There are various ways to see that. Some are on the pictures. There's signs in the middle of the road. There's signs on the side of the road on taller posts. There's notification on the back of every bollard and meter. And when somebody does go to pay at the meter, the first screen also reminds people that they must be backed in. So this vehicle was not backed in, which is why I issued a ticket.
Thank you. Ms. Waters?
I am here as authorized representative for the trust. So I'd like for that to be noted. It's not Ms. Waters, it's for the trust. And I sent you the document which states.
Your name is Ms. Waters.
I am the trustee.
We're here as the trustee of your trust.
Correct. I want that on record. And if we're going to proceed, and she has pictures.
We are going to proceed.
I
Please
need
go ahead. Ma'am?
If we are proceeding, I need discovery. If she has pictures, I need discovery. I need the same thing that she has.
You were there to see it all, ma'am.
Who?
You were there to see it.
There are pictures of me there?
Are you denying that you were there?
I've already denied for the
responsibility for the civil
asking,
infraction. Are you denying being there?
And I am asking for discovery, as is my right under anything, including a parking violation. Am I correct?
No, you are not correct.
I'm not due discovery on a parking violation?
You haven't properly filed for discovery.
My documents are on the record. You had them the very last time.
And the records are not reflective of reality that you've provided. A statement saying that you're entitled to a contract, and then you cite a statute that deals with the statute of frauds.
The motion for specific discovery is on the record, is it not?
I don't know that if you'd say it's on the record. It is in the file. You said that you served it personally, by mail, and by fax, I believe, that one of those three did get through. I have seen your motion, I have read your motion, and I have denied your motion. You can proceed.
I need discovery. If she has pictures and anything else, then I need to see that as well, as is my right. Also, St.
It is
Clair
not your right.
Matthews, you cannot ticket a trust. And that is clearly
That's
trust.
not true either, ma'am. The car was ticketed. The trust owns the car. You say.
And it is trust property. Meaning the trust has been ticketed.
The car was ticketed.
The car.
The trust owns the car. The owner of the car is responsible for parking tickets.
Which is the
that
trust.
are received.
I do not own that vehicle.
The trust does.
Exactly. So
What's
this
your point?
is why I'm asking for discovery. If
No.
there are pictures.
Ma'am, the testimony is clear. There are signs in the middle of the street directing back in parking only. The officer testified. She testified that the requirement to back in only is on the screen that's on the meter. She testified that it's on the sign prohibiting head-in parking is also on the poles that the meters are on.
I did hear that.
And any vertical surface has it.
I was not driving.
If you want to contest
I
that,
did
you
not
can
park
go.
the vehicle. So this is why I'm asking for discovery.
This is, ma'am, it's irrelevant.
When is discovery ever irrelevant? If she has something I don't have, both
But
parties.
it's not as to a material fact. And if you wanted to
Yeah, it is.
dispute the fact that are you disputing the fact that there's signage?
No, I'm disputing the fact that I don't have all of the same information that she claims that
Ma'am,
she has. So that
Let's talk about what you need. Are you disputing the fact that there is signage on Washington requiring back-in parking?
I wouldn't know because I haven't seen it. So I need to see the pictures.
Well, then you're not prepared for today. It's the finding of the court that you're responsible. The officer's testimony is uncontroverted. The fine is $50. You can pay it online or by mail, or you can drop by the courthouse and pay it. We are done.
What's your P number?
Figure it out.
I'll figure it out.
Oh.
My P number is 29798.
2979 what? H as in happy?
No, 8 as in between 7 and 9.
Thank you very much.
It has been almost 8 months since the double murder of a foster family. The biological mom accused of planning the attack with 2 men on New Year's Day in Washtenaw County, but now this horrific case is being delayed yet again. Lauren Kostick explains why.
After almost 8 months of waiting, victims of this brutal attack will now have to wait even longer for a trial after 42-year-old Siobhan Vincent decided she wants a new attorney. With a smirk on her face, Siobhan Vincent entered the courtroom for a preliminary examination Tuesday. But instead, her public defender removed himself from the case.
At this time, it has come to the point where there is an attorney-client breakdown of communication. I do not feel that I am able to effectively communicate with Ms. Vincent to help her with this case.
In return, Vincent smiled and nodded, even showing off what appeared to be a homemade T-shirt referencing her daughter. Vincent, along with Gregory Calhan and Keith Finley, are accused of murdering a foster family in Northfield Township on New Year's Day. Police say the trio broke into the home, killing Jennifer Bernhard and her father, Stevie Smith, and also shooting Jeffrey Bernhard. Investigators say the group then kidnapped 2 children, including Vincent's biological daughter. The judge Tuesday granting the motion for a new attorney before postponing the examination for another 2 weeks.
Anything additional?
Yeah, I just.
Ms. Vincent, trust me, God, trust me. Thank you. Nothing further, y'all.
In a statement, Jeffrey Bernhard said, "I know the court proceedings are going to take a while, but I am confident in the prosecutor's office and in the Northfield Township Police Department. They have done an outstanding job, and I really believe justice will be served." Vincent's co-defendants have already been sent to trial back in April. As for this new hearing, it is scheduled for August 5th. In Ann Arbor, Lauren Kostick, Local 4.
All right. Court does call the case of the People versus Benson.
Ready, Judge?
Good afternoon, Your Honor. Katie Rismer, for the People.
Portia Feaster, First Assistant Public Defender, on behalf of Ms. Vincent, who is approaching the podium. Ms. Vincent, when you arrive, please state your name for the record.
My name is Siobhan True Benson.
All right.
Thank you,
Your
Judge.
motion, sir.
Yes, this is our motion, Your Honor. We filed a motion to withdraw on this case. I have had the opportunity to speak to Ms. Vincent on this matter several times and to discuss the nature of this case. At this time, it has come to the point where there is an attorney-client breakdown of communication. I do not feel that I am able to effectively communicate with Ms. Vincent to help her with this case. This being a capital case and her fighting for her life in this matter, I believe she'd be better served with another attorney who she feels more comfortable with. And based on that, Your Honor, I ask that you allow our office to withdraw.
All right. Do the people have a position on the withdrawal?
No, Your Honor, leave that matter to the discretion of court. Thank you.
All right. Ms. Vincent, is this what you desire also?
Yes, I do. I need my own private attorney for this matter pertaining what's going on about my child. And I definitely stand tall for my baby. So I need for him to withdraw, I need to have my own attorney.
Well, when you say your own
Well,
attorney,
a different attorney.
you need a different attorney than the public defender's office.
Correct.
You would agree that communication between you and the public defender's office is broken down?
Yes.
All right. Given that, the court would indicate that the public defender is permitted to withdraw as counsel of record, I will sign the order. Discharge from any further obligation under the
I
case.
got it for you.
Sure now.
Stand tall for my daughter. Sorry.
The court, in anticipation that this might be the court's ruling, although not having decided it previously, the managed assigned counsel's office has appointed Corinne Johnson to represent Ms. Vincent.
Thank you very much, Judge. I believe he's here. Good luck to you.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Ms. Vincent.
And so, and the record should reflect there was a in-chambers conference, basically trying to anticipate, go this direction, where the public defender was to withdraw, anticipation to make sure that you'd be ready to proceed to preliminary examination. Without getting into the details of that, I think that all the evidence and other things will get to you rather promptly. And so I'd like to set this to adjourn the preliminary examination to August 5th, that Tuesday in the afternoon. And Miss Vincent, you understand that having allowed the public defender to withdraw, that your matters would be adjourned.
Yes, I do.
All right. Will that work for counsel?
Yes, Your Honor, the afternoon of August 5th, believe will work for counsel.
All right. Will that work
We'll
for?
be ready, Your Honor. Thank you.
All right. Then I will adjourn preliminary examination in this matter to August 5th, 2025. What I'm going to do is I'm going to set it at noon. As counsel is aware, there are preliminary examinations that are going on during that time. And so because I would need a courtroom with a lockup, I have to wait for those to clear, and then we would proceed immediately thereafter. So I'll set it at 12, but it may be a little bit after that.
Yes, sir, Your Honor.
All right. Anything additional?
Yeah, I just, oh,
Nothing further, Your Honor.
Thank you. All right, bond will continue as denied. Thank you.
Thank you.
And I give all of that. The court does call the case of the people versus Theophilus Smith.
Ooh. Thank you. Judge Simpson, I can speak.
It's your case.
Yes, I can tell you what happened. I've been in jail for 100.
Hold on. Theophilus.
We're ready in this matter, Honorable. I'm Brown Deputy Chief Defender appearing with and on behalf of Mr. Smith, who appears by Zoom. Mr. Smith, could you state your name for the record?
Theophilus D'Angelo Smith.
All right, you're requesting a forensic evaluation?
Yes, I think this matter is still,
No,
there's one
I can speak for my Lauren Brown. Please don't say that. Please don't say that. That's insult my intelligence. That's insult my intelligence. No. You ain't even advocate with me. I will speak on my own behalf, and then you can
I
tell
believe
me.
there's one that's pending already.
Your Honor, the last update I have from May is that he was found incompetent but restorable, and
Right.
today was it had been scheduled on the 31st to check in.
No, come on, like,
And
come
we,
on.
so
Can I
has the
speak,
court,
please? Can I speak, please? Without
one moment,
okay.
one moment,
I
please.
can
Mrs.
easily, I don't want to have to do it, but just let
It's
me
already been
speak,
sent
please.
out for one.
You get a chance, but wait on just a minute so that we can make sure that what you say has meaning.
No.
Has the court received an
Every
updated?
word I speak, that mean I say
I have
something
not.
wrong.
All right, Mr. Smith, I'm not gonna try to talk over you.
Okay, go ahead.
I am not gonna try to talk over you. So if you wanna keep doing that, then I'll just mute you. Have a seat. Let me. Okay. Or dance.
Please, no, I need to speak. I don't got time to be, I speak for myself.
Okay, Mr. Smith. You need to have a seat and don't interrupt me.
So, Your Honor, has the court received an updated report with respect to Mr. Smith?
I have not.
We have nothing further to present at this time. Would you request that this matter be adjourned so that we can get an updated report?
And on the new case, requesting a forensic.
Yes.
All right. So on both of these matters, the one is set for a competency review.
Right, exactly right. The other is just tagging along with it.
So the new one, I'll set a competency. We don't have a new report, but one is coming in soon. So why don't you give me 45 days? Well, let's just give me the 90 and then I'll
October 23rd.
I'll adjourn this to October 23rd, 2025, 9 a.m. Mr. Smith, you're muted.
My life.
All right. Mr. Smith, what do you want to tell me? I'm going to give you 2 minutes to tell me what you want to tell me.
Me sleeping in the worst cell and radiation. Me can't lay down without men feasting over me when I wake up. I gotta pray hard. I gotta sing, and the Holy Ghost be in me. And they praying over me. They beat me. I'm just saying, an ends to a means. Like everything's been recorded. Everybody know everything. Simpson, please, Simpson, do America a great justice. Injustice anywhere is a threat to justice everywhere. Please,
Okay.
I can tell you more. I can tell you names. I'm tired. I'm scared to tell everything while I'm in here. My family is scared for me life. No, just do the right thing. I just ask you, I believe you are a judge that speaks justice. I believe you will just come on, just do the right thing. And my Lord, I trust. Amen.
I've done the right thing. We'll see you at the next hearing date, okay? Thank you, Mr. Smith. You can mute it now. Bond continued. Court calls case People versus Savannah Crittenden.
Have a great day too.
You do the same.
Good morning, Your Honor. Robert Ellman with it on behalf of Ms. Crittenden. Ms. Crittenden, can you please state your name for the record?
Savannah Crittenden.
You're requesting an adjournment. You were just recently appointed.
Yes, Your Honor, I was just appointed yesterday, so I don't have discovery yet on this matter. However, when appropriate, I would like to address bond.
Adjourn the matter July 31st, 2025, 9 a.m. Yes, that's the bond briefing.
Your Honor, it's my understanding that these alleged incidents allegedly took place at an extended stay hotel while Ms. Crittenden's apartment complex was under construction. She has before staying in that extended stay hotel, had not known, and I would argue still does not know, the alleged complaining witness in this case, has no reason to have contact with them. I'm still trying to determine whether the construction at her apartment complex is complete. But Your Honor, I think that given the circumstances, I'd be asking for a release on a PR bond with a GPS tether with potentially a no-go to that extended stay hotel.
Response.
Your Honor, we would ask that the bond continue as set until the next probable cause conference date. The defendant was under investigation for criminal sexual conduct with a minor. That investigation was furthered for other information to be obtained. Ms. Crittenden was advised not to have any contact with the minor or his father, although there was no bond condition. She immediately went back to the hotel, had contact with the minor and his father. Police had to be called. The police came out, instructed her not to have contact with the minor and his father. The police left the hotel and were dispatched back again. She was having contact with the minor and the father and making threats hence the stalking charges. So we would ask that the bond continue.
And Your Honor, if I may,
yes.
Again, I just want to make sure it's clear. The CSC allegations, it's the same complaining witness as in the stalking charge. And again,
I'm just gonna get that.
So I just want to make sure that was clear, Your Honor. And again, I don't believe she has any reason to have contact with them. And I think a GPS tether with a no-go.
But as I understand, she was told she was under investigation for a CSC, told not to have any contact with this specific individual as well as his father.
And she denies those allegations, Your Honor.
Understood, but the allegation is that then the police were called back twice after she was informed of that, and that there were threats, which, as Ms. Reiser's indicating, have led to the stalking charge. I'm actually, given those allegations, surprised that her bond is set so low. Motion for bond reduction is denied. Bond.
Thank you, Your Honor. One more thing, Your Honor. I apologize. I was hopeful that Ms. Crittenden would be released and then we could have an afternoon spot on the 31st. I do have a conflict in the morning.
You can talk about this. Well, it's going to be in the morning.
Right. No.
Put it on the 7th.
That's what I'm asking for, Your Honor.
All right. Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue. Motion for bond reduction having been done.
Thank you, Your Honor.
Court does call the cases of the People versus Joshua Palfrey.
I present on behalf of the people, Your Honor.
We're ready in that matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Palfrey.
Your name, sir?
Joshua Palfrey.
All right. What are you doing on this, Mr. Brown? These. It's 4 cases.
Your Honor, today's the day. Sorry. Your Honor, today's the date and time set for a probable cause conference. We still don't have all the discovery. We're pending discovery on adjournment. Well, we should.
Your Honor,
I don't want to
adjournment.
Well, we can't do anything without this.
I'm not saying adjournment. I got due process. By the end of this year, beginning of next.
I'm gonna tell you that we
That
need
can be
adjournment.
that.
All right.
I want an adjournment. I want to schedule preliminary examination.
Your Honor, we would like to be able to have the discovery. We, despite my client's misgivings, would like to have an adjournment to get that discovery. He wishes not to have an adjournment and schedule it for preliminary examination. I'm advising him that that is not the proper or appropriate way to handle.
And Your Honor, on one of the cases, they haven't even received any approval yet. It was just released this month.
It's because some of the cases are, I need a preliminary examination.
What? I can't hear you.
I don't want an adjournment. I want a preliminary examination. I don't want to keep adjourning my probable cause conference and pushing out my prelim. We got a right to due process, 14 days.
Okay, you want due process? We'll give you due process. Give me a date before me. We'll just do it. And then that way, when your counsel doesn't have discovery, you have no complaint against counsel. When it just goes south for you. Now, I need a date earlier than that.
That's a smart idea.
So they don't have that.
I'll set preliminary examination in person before me, August 4th. That's a Monday, 2025, 9 a.m. I will indicate that while I'm setting it over the objection of defense counsel at defendant's request, that if the discovery is not there, they haven't analyzed it, we're still going ahead. Put that in the file. He wants an exam, I'll give him an exam. Thank you, bond continued.
For the record, I want to make it clear that this is against counsel's advice.
Yes, and I've stated that, and I've noted that Mr. Brown, this is against his attorney's advice. He wants to do that with his own law degree. Thank you, bye.
Thank you.
You do the same, Mr. Pelfrey. Court calls the case, People versus Bradley Chavez.
Assistant Public.
Is this yours?
It is mine.
Is this gonna go well? No, is this gonna go well? Ms. Akinrulli, is this gonna go well?
It's
'Cause
gonna go
you've
great.
had 3
It's gonna
and you're 50% right now.
go.
Oh,
His shirt matches.
Mr. Chavez. Can you state your name for the record, please?
Bradley Chavez. Morning, Your Honor.
Thank you, sir.
It's matching the green sheet, Judge.
Yes, he is.
Assistant Public Defender Chinazi K. Akinrulli, Your Honor, on behalf of Mr. Chavez. Your Honor, we are in the midst of negotiations. I think the people and I may have come to a resolution. I just need to let Mr. Chavez know. And hopefully we can get this resolved at our next hearing. So we're asking for an adjournment.
August 7th.
Thank you.
2025, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Where'd Cannon go?
Double duty, Judge.
So she chose the other duty instead of this one?
No, she's
No,
here.
is that what you're telling me?
She
She chose to be someplace else than before me.
They dragged her kicking and screaming. I said, no.
Was it kicking and screaming? Okay. Oh, apparently she survived. Hello, Miss Cannon.
How are you?
So just out of curiosity to see if they were telling me the truth, where were you?
Next door,
Did they drag you over there kicking and screaming?
they asked if anybody was available.
And so you volunteered to leave here and go there because you'd rather be there? Is that what happened?
Never.
That's not what happened?
You didn't see them dragging me out?
You and Lauren Brown ought to stop. Court calls the case, People versus Deshaun Clifton. Just in time.
Stephanie Cannon on behalf of Mr. Clifton. Mr. Clifton, could you please state your name for the record?
John Clifton.
Your Honor, I did receive some information this morning regarding our plea negotiations from Mr. Banis. I have not had the opportunity to review that. I'm asking for a 2-week adjournment.
I'll adjourn this case August 7th, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Thank you. Court calls case.
Case.
Oh, this is the one she missed when she was someplace else. Is that this one, this green form? That didn't get to me even though I granted the adjournment?
That is correct, Your Honor.
Because Miss Cannon was someplace else that she preferred to be other than here before me?
I'm gonna talk to them about assault by strangulation. Based on what happened.
I'm telling you, what they told me. Court calls case, People versus Collins Spry.
Assistant Public Defender Alexis Ertzwithen on behalf of Mr. Spry, who is approaching. If you can state your name for the record, please.
Colin Joshua Spry.
Your Honor, we'd respectfully requesting an adjournment. We're currently in plea negotiations with the people.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Okay. Court calls the case, People versus John Michael Nowak.
Alexander, on behalf of the people, Your Honor.
Stephanie Cannon on behalf of Mr. Nowak. He just looks like an Alexander.
What?
Looks like what? An Alexander.
Oh, is that how you figure out who your client is? Is that what you do?
In that moment.
I call the case, she goes, he looks like an Alexander, come on up. Is that what you do?
Yeah, it's like, what? We literally talked this morning. Like, what?
Oh, we did talk.
Yes.
You made an impression. Wow. Cannon.
Well, good news, Your Honor, it's for a plea.
No, I do see that. But this plea form's for Alexander.
No,
I'm kidding.
Oh,
all right.
I was like,
You
oh my
just
God.
you absolutely froze.
I did.
You had no. Sir, did you state your name?
No, I didn't. I'm sorry.
Could you state your name so she knows it now?
John Nowak.
John Nowak.
I have before me a form that indicates that the defendant will be pleading guilty to count 2, which is malicious destruction of property, 200 to 1,000 to 1-year offense. Upon a successful plea to that charge, and count 1, right, would be dismissed. Defendant also in this is agreeing to pay restitution in the amount of $1,635. And that he would be sentenced under a prosecutor's, there's a sentence agreement of sentencing under a prosecutor's preferred.
That's correct, Your Honor.
That is my complete and full understanding of the agreement.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
John Nowak.
Did you say your last name?
Nowak. Yeah.
Okay, thank you. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that could become the maximum fine. You understand that, sir?
Yes.
Okay. You understand also, sir, that when I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights, which you should take a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're picking up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Not yet.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Very much.
On the date of June 4th, 2025, at the location of 1235 Astor Avenue in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do involving a Honda Civic belonging to Olivia, is it Holsing, that makes you think that you're guilty?
I drove there. I mean, I could give the whole sob story.
No, just tell them what you did.
But what I did was that I drove there. I spray painted cheater on the left side of the car, liar on the right, and FU across the hood.
Because, yeah, that would be a long story, probably to tell.
Yeah.
Okay.
All that matters.
You were angry about something. You went up and damaged your car.
All that matters is that I'm here to take accountability for what I did. Chelsea advised me against bringing it. I do have these here to show that they're statements from friends that know me.
That'd be, if we do, it'll be for sentencing judge, not for him. He just needs the facts and he's
Okay.
gonna.
But
act
okay, I'm
accordingly.
sorry. I'm getting ahead of myself. But yes. That I did that.
Do you agree the amount of the damage was at least $1,635?
At least yes.
Pardon?
At least yes.
Yes. All right.
Sorry.
Okay, so I do have to advise you. Sir, that if you commit misconduct after I accept your plea and before sentencing, that any type of evaluation of sentencing agreement, the court would no longer be bound by. You understand that?
Yes.
And you would also not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
Have I complied with the court rule, and would it be proper to accept this?
Yes, Your Honor.
The court has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 15th at 8:30 with Judge Perry.
August 15th, 2025, 8:30 before Judge Perry. Bond will continue.
Thank you so much, Your Honor.
All right, thank you.
Copy that.
They were ready. Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Townhouse, this was attorney by people.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir? Larry. All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted, as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw. And basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, inter-office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Fact. Are we talking a 1 month or a 2-week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the time to wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. And I have reviewed
I'm going to probably believe that there's more than just 2 pages.
I just provided copies too, Judge, when he was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lay?
I would like to proceed today.
Okay, you understand that it cannot finish today?
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lay?
Yes.
I think I'm gonna be honest with you. I think you're just telling me yes, thinking that you're gonna get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do
today.
you have a copy of the discovery?
My attorney hasn't provided me with a copy.
True, Judge. I gave it to him on May 8th. He was at my office. He got it.
Well, the 2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr.
No. If you're, no.
Do you still? This way. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Should be available. And I August 8th, Your Honor?
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to, so if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we're ready to proceed today. The victim is here on this visitor's waiting since this morning. Victim has also been here previously waiting for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm going to be done. If you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay, we're going to go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just. Pardon? All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You understand that, sir? And you understand that you will not be, the court is not going to treat you worse and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, is that and the bond violation.
Yes. The defense is requesting you to examine the information between myself and my attorney, because I am alleging that I did not violate the bond, the condition of the no contact order in my bond, and witness tampering that the prosecution says that I'm guilty of, and the text messages prove.
You're asking me to look at information that would be relevant to the bond hearing?
The text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
And I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you.
All right, this is the Destiny's race. This is the city of Detroit, Mr. Berry versus Destiny Graves, case number SB 1069059, counts 1 and counts 2, SB 172478881, SB 1724805, counts 1, 2, and 3, and SB 1724836. Appearance for the city, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase R-A-V-E-S. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established in the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's Destiny, lowercase E-S-T-I-N-E-Y hyphen capital R, lowercase A-I-V-Y-N colon capital G, lowercase R-A-V-E-S.
Okay. Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay, so, I mean, if you can't give me an answer to my question, then I'm gonna put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again?
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm gonna pass the matter. All right, let's go to, what is that? You're on, Ms. Mendez? This is the city of Detroit versus Torino Law, case number SP 1659461. Here, let me state your name for the record, please.
Torino Love.
All right, Mr. Lowe, turn your camera on.
Oh, it's not on. Wait, it says it's on. Wait, why is it not?
It's on, I can't see you.
Oh, wait, I'm sorry. Here you go. I got a thing on my computer. I forgot.
Do you have some clothes on, sir?
Yes,
You have a shirt on?
yes. I'm not. I'm just closing the camera.
I don't believe you.
I don't like. Yeah, I'm like.
Let me see if you're telling me the truth or not.
I'm like right here.
Do you have a shirt on? I asked you.
It's a short. It's not a. I'll put a different shirt on.
No, you're lying to me, sir.
I'll put a different shirt on.
Why? Yes. Mr. Lowe, you coming in person tomorrow?
First of tomorrow?
Yes. Lying.
Oh man, I had like a little thing. I had like a gym shirt
I don't
on.
want to
That
hear,
was like crop.
hear your explanation. I don't want to keep hearing you continue to lie to me. Back on the record with Mr. Lowe. Come here tomorrow at 8:25.
8:25, clear.
You still haven't paid your obligation either.
It should be taken care of now. I handled it.
Not taken care of.
I definitely handled that. Make sure I was clear before I came in today.
Should have made sure you were dressed before you came in today. It's not taken care of. You still owe $240. Come in tomorrow morning at 8:25.
Clear.
Be safe. Best of luck to you.
Thank you. See you in the morning.
Please. Good morning, everyone. I'm gonna do the best I can to get you out as fast and efficiently as possible. And I'm gonna do the best I can to get you out in the order that you came in. So I'm gonna start with the reviews. This is the city of Detroit.
Yes, sir.
Versus Lowe, case number SD 165-94631. Mr. Lowe, good morning to you. State your name for the record, please.
Good morning, Tamina Love.
All right, Mr. Lowe, today's date and time again set for a review. You still haven't paid.
Okay, so the thing must not have went through.
I told you to come down here today, didn't I?
No.
Now, I did tell you to come down here today.
No, well, yesterday, we haven't had it not to come down
Came in
like in
without the
person
shirt.
today.
Came in without the shirt on, didn't you?
Yeah, that was the thing yesterday.
I told you to come in today. All right, now I'm gonna put you out. You get down here. You're defying what the court order I told you to do.
Oh,
and you still have to pay.
I didn't hear the come down in person today. I'm not even.
You did hear it. Don't. Let's not go there, Mr. Lowe.
No, I didn't. I actually didn't hear you say that. I just heard you to return
All right, well,
back in the morning.
You hear me now?
I'm not able to get there in person because I'm like out of town on a job.
I'm gonna put you back in the waiting room. All right, let's go back on the record with Mr. Lowe. Mr. Lowe, I don't believe two things. I don't believe you didn't know that I told you to come. You acknowledge that. We can bring back the tape, and I can show you your acknowledgement on that. I recall that distinctly. I told you to come in this morning. You said you want me to come in the morning. Yes, I'll be down. I'll be down in the morning. And the second thing, I don't believe that you are out of town. I don't believe it. You come on, you lied to me already about not having a shirt on when you came into court yesterday. I think you're lying to me now when you say that you didn't know. I told you to come in person tomorrow morning, and I think you're lying to me about being out of town.
Your Honor, I honestly didn't hear you say come in person. The in person part I didn't hear.
We're not gonna keep going back over that because I don't believe you.
Okay, I can show you. I'm in my hotel room right now. I can show you that I'm out of town.
I do not care where you are.
What? Yeah, I'm currently in Toronto because I'm out of town on a tour. Because I'm like in the middle of, I'm out on a job right now.
Well, you're gonna, when did you go to Toronto?
I flew into Toronto after we got off of court, after we got off the Zoom this morning, yesterday morning. Because my flight was yesterday after court.
Yeah, and you didn't say that. You said you were coming in tomorrow morning. Miss Williams Law, do you have the transcript? Can we look that transcript back up for tomorrow morning? I mean, yesterday with Mr. Lowe.
Yes, Judge.
He also told me that he paid his fines and costs and he took care of that, and that hasn't been paid. You're just a liar.
Oh, yeah, I sat down with my grandmother. I thought we took care of this. It must not have went through.
You're just a liar, sir. No, I don't need you to be any editorial, Mr. Law. Yeah, you just continue to lie to me. Let's pass the matter.
Judge, would you like for me to try to, we can go off?
Yeah, we don't have to do it right now. He's gonna wait.
Okay.
And we'll get it, and we'll see exactly what he said yesterday. Should have made sure you were dressed before you came in today. It's not taken care of. You still owe $240. Come in tomorrow morning at 8:25.
Clear.
Be safe. Best of luck to you.
Thank you. See you in the morning.
Let's go back on the record with Mr. Lowe. Did you get that transcript, Ms. Harris? Were you able to do that?
You're talking to me, Your Honor?
I'm sorry, Ms. Williams. Sorry.
No, Your Honor, we'd have to go off the record for me to do that, but I can. We just haven't gotten a chance to go off the record for that amount of time.
Let's go back on the record with Mr. Lowe. I'm so sick and tired of these people coming in here lying to me. I'm sick and tired of it. He's on tour or he's on something for in Toronto, but he can't pay $240. He's got to get his grandmother to pay it. When are you coming back?
To Detroit, I'll be back in Michigan. I'll be back in Detroit August 11th or 12th. It was one of those 2 days.
Come back August, you're coming in person August 12th. See if your grandmother will pay your fines for you. $240, come in person. You have the money, If it's not paid, have the money in hand on August the 12th, come on down to the courthouse. Now, you understand that?
I'm clear.
All right, you were clear yesterday. But you think this is some kind, you think this is some kind of game I'm playing with you. I'm not.
No. My understanding yesterday, I thought you
I don't
told
need
me
to
to
hear
come
your
back to the
understanding.
Zoom.
I don't need to hear your understanding.